American Chamber of Commerce's hybrid seminar on hot topics related to arbitration seated in or related to Brazil in partnership with King and Spalding LLP. Thank you all for attending, whether you're in person or remote. Again, special thanks to King and Spalding for hosting and helping organize this wonderful event.
It's a well-known fact that the Brazilian Arbitration Act permits the use of arbitration against the state and against the state-owned companies. A clear example of that are contracts regarding different fields, such as infrastructure, oil and gas, telecom, energy, and ports. If we refer to corporations, the Brazilian Corporations Act was amended to establish that the arbitral clause included in the bylaws binds all the shareholders. As a consequence, most of corporate disputes involving publicly traded companies are resolved through arbitration. With respect to the judicial scene, Brazil is a notorious arbitration-friendly jurisdiction with a solid jurisprudence of the Superior Court of Justice with the application of the competence conflict principle. Nevertheless, in spite of the several precedents honoring the competence principle by recognizing the precedence of the arbitral tribunal over the state court in assessing its own jurisdiction, there is a device whose use ultimately represents the denial of such principle. My friends, please meet the conflict of jurisdiction, or conflito de competência in Portuguese. The conflict of jurisdiction is not an appeal, but rather an incidental motion filed in proceedings in which a conflict arises, resulting from a disagreement between state or federal courts, undecided by a higher body than the ones in conflict. A conflict of jurisdiction may be filed when two or more judicial courts assert their jurisdiction, leading as a consequence to a positive conflict, or when both courts refuse jurisdiction, thus a negative conflict.
And what happened with Petrobras investors' claims, which is called a Petrobras claim? That is a recent case in which, through conflict of jurisdiction and our jurisprudence, unfortunately, that have been consolidating arbitration involving state entities, opened an exception to what the regulators have done, and an exception to what the Superior Court of Justice have been applying in the past. In the past, as Marcelo mentioned, the competence principle was recognized. So the arbitral tribunals had priority. They have the preference to say whether this claim could be arbitrated, whether this claim, the parties that are involved have chosen the application of the arbitration clause, and whether also the scope of the arbitration should be subject to, the scope of the clause should be, and the dispute should be subject to arbitration. So the parties could only discuss that after there was an award, in the case of a set-aside proceeding before Brazilian courts. Otherwise, you have to apply competence, and the arbitral tribunal will decide. Well, in the Petrobras case, there were a big number of investors that started to challenge the decisions and the acts of the government as the controlling shareholder of Petrobras, due to the corruption acts that were disclosed in Lava Jato operation. So what if it was, what if these companies like Petrobras, Eletrobras, and which our government is currently considering to privatize, at least has been promising for some time, what if they were controlled by private entities? So we would have a purely corporate dispute, and very likely the provisions of our Arbitration Act that bind all the shareholders would be applied. So we think that privatization would not only be a discussion on whether it brings economic advantages and efficiency, but also in regard to dispute resolution, it would favor arbitration, because it would be much easier to have arbitration applied to parties when they are private parties. It would be merely a commercial case.
that Petrobras is, if I can say so, a different animal. Because if you take in consideration 2 years ago, 2 years before that decision, we had a famous decision on the Parque das Baleias case, which was opposing the oil and gas agency. And the Superior Court of Justice decided that the principle of competence was applicable, and as a consequence, they have deferred to the arbitral tribunal the preliminary view on its own competence. So I'm not talking about bad news only, but just for our international friends to be acquainted with this animal related to conflict of jurisdiction, and also the animal related to Petrobras, because this changes a lot the environment here in Brazil.
There are currently 2,646 bilateral investment treaties and treaties with investment protection in force. You can see in the 1990s, there was a spike in activity and entering into bilateral investment treaties. And I would say, I think it's safe to say, and I think Tim and Julie and Erica will agree, that a lot of the treaties entered into in that time period have broad protections, and we like those because we mostly represent investors against states.
Now, Brazil is not the only one that to obtain protection, treaty protection, would need, it's sort of restructuring of its investments, or a wise structuring of its investments. So companies around the world have benefited from structuring or restructuring their investments in a way that will allow them to benefit from protections given by treaties that were signed between the state that is hosting their investments and other states that are not necessarily their original states. And usually this is done when there is no treaty between the investor's home state and the host state, or when there is a treaty in force, but that treaty does not protect the investor or its investment, or it provides for very limited access to investor state arbitration, or no access, or substantive protections that are inferior, and you would prefer to use another treaty. So in the case of Brazil, as you will probably know, there are no treaties in force providing for access to investor state arbitration. David just mentioned that. Now, Brazil has signed some BITs in the 90s, those of the generation that had broad protection, and that included investor state arbitration, but those were never ratified. So they are not in force. And more recently, all of the BITs that were signed by Brazil do not provide access to investor state arbitration. And many of them are actually not ratified. In last year, there was a BIT with India, in 2019 with Ecuador and some other countries. We have one with Chile and Colombia in 2015. But the only ones that are in force right now are the ones with Mexico and Angola, and they do not provide access to investor states. So let's say that Brazilian company has a direct investment in Peru. No BIT between Brazil and Peru. The Brazilian investor has no protection of its investments in Peru. Now, if they insert a special purpose vehicle company incorporated in Luxembourg, by having that company directly holding the investment in Peru, they might be able to benefit from protection of the Luxembourg-Peru BIT.
As they say, timing is everything, because some clients will come to you and want to restructure, but they're already in a row with the government, or there's a foreseeable dispute with the government. And then there are quite a number of cases that if you restructure after that point in time, you may be bounced on jurisdictional grounds for really treaty shopping when you knew that there was a dispute either underway or brewing, and then you ran a restructure to gain treaty protection.
The United States conception of discovery is very broad and very different to, at least as I understand it, the concept of document or testimonial disclosure in Brazil. Now, in 1964, Congress, in its infinite wisdom, and sometimes I lapse into questioning that wisdom, but still, Congress passed a statute called 1782, Title 28 US Code 1782, which states relevantly that a federal court, any federal court of the United States, can order a person residing in that district, and a person can be a corporation, a bank, an individual, anyone who lives or is doing business in the jurisdiction, to give testimony or a statement or produce a document or thing for use in a proceeding in a, quote, foreign or international tribunal. So that's a wonderful phrase. What is a foreign or international tribunal? It is any court located overseas. It is also any quasi-investigative or administrative body located overseas. It also might be, and this is a nice question, hotly debated, it might even be an international arbitration tribunal located in Sao Paulo or Rio. That's just one of the possibilities. That means, however, that if you are a Brazilian litigant, that is a person litigating in the state or federal courts within the various regions of Brazil, and you find someone located in the United States who might have goodies, that is to say, a nice little iPhone with WhatsApp, incriminating WhatsApp messages, or a file or a repository, or just something in their head that they can be asked about, you can find them in the United States, go to the federal court where they live or where they're headquartered in the case of banks or corporations, and ask the court to subpoena them so that you can get testimony under Section 1782 in aid of the Brazilian case. Now, the statute does require that the information you're seeking is reasonably related to the Brazilian litigation, but there's a vast array, and actually I get alerts every day from Westlaw. There's a vast array of possibilities. There's, you could name virtually any court in Brazil, any kind of court, and you could find a 1782 case where discovery has been ordered in aid of proceedings in that court. It doesn't have to even be commercial. It can be family, it can be criminal, it can be white collar.
Bankruptcy.
And bankruptcy has actually been a recent option. And that is a very powerful weapon. It not only does it allow you to issue a document subpoena, which means turn over all your emails, WhatsApp messages or texts, but it also gets you an extra bonus. It gets you the possibility of getting a deposition from a United States individual. We as lawyers think of depositions as a wonderful opportunity to question a witness and flush their memory of the case and their specific knowledge of everything to do with the case. My clients don't always have that same feeling. One client described a deposition to me as 8 hours talking to somebody I hate. I hope that they were referring to the other side, but at any rate, it is an uncomfortable experience to be asked questions in a deposition, and it can be something very powerful, as I say, for the plaintiff. And I defend as many of these applications as I've pursued, you know, you really start having to look around for reasons not to have to give depositions or discovery when you receive a 1782 subpoena, because the standards of Section 1782 for whether a court will grant 1782 discovery, I have to say, and I say this as somebody who often defends this, they're quite permissive. You merely have to show that there exists a litigation overseas and that the target has material information. I've had cases where a 1782 application is successfully pursued even before the litigation begins overseas. This is an Australian case I have in mind, but you only need to show that a dispute is in reasonable contemplation of the parties in order to kick off. You don't even need to show, for instance, that discovery is available reciprocally. For instance, you might think that when the statute was enacted, that our lawmakers might say, well, hang on a moment, you should only be able to get discovery in the US in aid of a Brazilian case if you can show the Brazilian court will give the same kind of discovery for the parties in that case. Wouldn't that make sense? Well, it might make sense, but it's not in the statute. There's no reciprocity requirement. And as I say, you know, when I'm defending these cases, that can lead to a very awkward conversation with the client that's been targeted. But when I'm pursuing these cases, we can easily wave aside that kind of objection.
Maybe two brief additional comments on that. In your spare time, pick up the congressional record on the history of 1782. And you will read that the reason why this provision is on the books was actually based on the premise that if we offered discovery in the United States in aid of foreign proceedings, foreign nations might embrace discovery and might actually emulate US discovery. You know what happened. Nothing of the sort. And instead, this is really just used against, for the most part, US corporations. It is a very odd provision of US law, a very powerful one also, as Timothy explained, so much so that sometimes drafting a mere letter announcing that you would be bringing a 1782 might give you just as much by way of results for a client than bringing the proceeding itself. So it's certainly of interest for any type of Brazilian proceeding.
I think we're starting to change to a new trend, and of course, this is all empirical. It's you know, what we have seen in our day-to-day. We have seen a growing number of cases that are related to the pandemic, and this is interesting because I thought at the beginning of the pandemic that all these cases would be related to negative results. You know, there'll be MAC clauses being enforced. You know, buyers trying to walk away from deals that were signed, and that, you know, at least I haven't seen that happen. What happened was the opposite. You know, there were some markets and some products that were very positively affected by the pandemic, and you know, you can think of the obvious examples. You know, a pharma company that makes vaccines. You know, Chinese plant that churns masks. Of course, these guys are doing very well. But also, you know, the IT companies, online retailers, and for Brazil, there's a commodity super cycle. So all the commodities companies are having fantastic performances, often you know, reaching historical sales, historical revenues. So you know, some deals that were closed or signed with a long time between signing and closing, or deals that have an earnout, which I think most of you are familiar with this type of provision. They became like an issue, especially for whoever has to pay for it, because there's a possible excessiveness in the amount to be paid in an earnout, and an element that is often not related to, you know, to decisions that were taken by management. These results, in some cases, could be deemed artificial, and we're starting to see some cases with that type of discussion, which are really interesting. So I think, you know, this would be a trend. If a company want to be listed in the highest governance ranks in the Brazilian Stock Exchange, this company must include an arbitration provision in their bylaws, which it makes literally half the companies listed in Bovespa and B3 are subject to binding arbitration. And interestingly enough, the Bovespa saw this as a good opportunity to create their own arbitration chamber that has the monopoly of all these cases. So all these cases are heard by the B3 arbitration chamber. And if this is not enough, there's a number of closely held companies that also, you know, deliberately included arbitration provisions in their bylaws, because, this in Brazil is considered good corporate governance. The IBGC, which maybe some of you are familiar with, it's a Brazilian NGO of corporate governance for over 20 years, recommends companies to include arbitration provisions in their bylaws as a matter of good governance.
Our next event is a holiday reception on the 8th of December, hosted by Onati at their Midtown showroom. So I am, sorry, Arthur, the only thing keeping those present from the cocktail hour. I was thinking of giving a small lecture on the economic implications of Roman versus common law, but I think I'll save that for another time. So Bess, we'll end here and wish you all health and happiness in the coming days. Thank you.